Hello, Carla Hartley here, and today I'm continuing our discussion of precisely how you should engage in certain exit strategies. Right. I want to discuss in today's video the issue of support. I'm breaking this into two pieces. Today's video will discuss if you are the supported spouse, how your support award can be increased or reduced by your behavior. And I will discuss in another segment how to reduce the support obligation of a supporting party. The first dichotomy I have in this discussion of support is whether there are or are not children of the relationship. If there are children, then obviously child support is going to be a factor. It's going to affect the amount of spousal support that is awarded if this is a marriage. But if there are children but no marriage, then the child support order is pretty much the only support order we're looking at, unless there is some sort of Marvin action, which would be called a palimony action. Those are generally disfavored and largely unsuccessful, but we have to mention them. Okay, so with regard to children, the amount of support that you're going to pay or receive is going to depend on two factors, your income and on the percent of your custodial timeshare with your children. The sort of pre-planning that goes into the custodial timeshare percentage is going to fall under my discussion of custodial exit strategies. But I want to be really, really clear that when I'm talking about custodial exit strategies, you really should be looking at doing what's best for your children and not for yourself financially. Again, that's a different discussion. Today, I'm going to stick with the no kids discussion of support. So in this chat, we're mostly discussing spousal support, obviously. A lot of these principles, because I'm discussing the supported party, will apply to a child support action as well. In the context of support for a supported party, and again, mostly this applies to spousal support, we are looking at how you can plan in advance, if you are the supported spouse, to increase your support award. We're also going to look at some of the actions that people take thinking they're increasing their support award, which have net negative effects for these parties. Sadly, very sadly, I'm going to say that many supported spouses choose to divest themselves of the ability to earn income a year or a couple of years prior to seeking the dissolution of marriage, sometimes for a longer period than 2 or 3 years. Let me be clear, this comment is not aimed at people in long-term relationships, long-term marriages, where one party has stayed at home, raised the kids to their adulthood, and has done everything he or she was supposed to do in the marital relationship by agreement of the parties. Now, where that marital relationship, that long-term marital relationship is winding down, is not what I'm aiming at with this discussion. Not at all. I want to be very clear on that. I'm talking here about somebody who is working, who has been working, has an ability to work, who has the possibility or even the existence of a good career, but for some reason, usually part of their pre-planning, chooses a year or two prior to the dissolution to stop working. Just stop working. This is really long-term self-destructive behavior. It is self-destructive on at least 3 counts. First, support is never going to make up on a dollar-for-dollar basis what you could be earning. What you can be earning will fractionally, or what you do earn will fractionally reduce your spousal support award, but it is not a dollar-for-dollar difference. Supported spouses are almost always better off financially in terms of total household income to actually be working. Now, second, the court is going to require you to return to the workforce. So unless you've got health concerns that make it impossible. But assume we're talking about your normal healthy person who's been working, who's capable of working. The court is going to require you to return to the workforce. So now what you've done is you've added your litigation costs by stopping your work prior to your dissolution. You add to your litigation costs because now you're going to have a temporary support order that's going to be substantially higher than your spouse feels that he or she should pay. You're going to end up with orders for probably a vocational evaluation that's going to be performed by an expert appointed by the court, or chosen by opposing party, which is aimed at getting you back to work. Then you're going to have to go back to court when you're finally returning to work because your ex wants to reduce his or her support obligation now that you're working. So as you can see, the cost-benefit analysis of that maneuver in these circumstances is really negative. Often, the legal fees will cost more than the increase in support that you temporarily got. It hurts both parties in the long run, and it primarily hurts the supported spouse. The third way this maneuver will hurt the supported spouse is perhaps even more significant. By stopping work a year or two before the date of separation as part of your exit strategy, you decrease the marital standard of living of the parties. By decreasing the marital standard of living of the community, which is averaged usually over the past 2 to 3 years of marriage prior to separation, you have decreased the amount that a court would look at and say, this is the marital standard of living in this community. To clarify, say you're earning $5,000 a month and your spouse is earning $10,000 a month. This would give the community, the two of you, a marital standard of living of $15,000 a month for two people. So you quit your job, and then we've got 2 years prior to the date of separation wherein the marital standard of living is only $10,000, not $15,000. Had you continued working, the marital standard of living would have been substantially higher. So this is an important issue because the marital standard of living provides a cap on what you can receive as your total income from employment and from support. Combined, that's a combined number. So again, let's go with if the combined marital standard of living is $15,000 a month, divided by 2, which is an incredible oversimplification, that would be $7,500 per month as the marital standard of living. Let's look at this and say if you return to work and you're earning $5,000 a month, you would still be entitled to roughly, and I'm so spitballing this, $2,500 a month from opposing party. That's if you kept working and if the marital standard of living was $15,000 a month. Now, you stopped working and the marital standard of living is solely your future ex's wages, and that's $10,000 a month. So, again oversimplifying, now the marital standard of living is $5,000 a month. You go back to work in your old job and you're making $5,000 a month. That $5,000 is the cap on the combined income you can receive from spousal support and from your own employment. So you have just maneuvered your way out of $2,500 a month of support. This is a significant loss because it lasts for more than that temporary period of time between the date you file for separation and get temporary spousal support and the date of judgment, which can be a couple years if it's stretched out, sometimes 3 years. You've got the rest of your life in many cases. The only time this would make sense is if you got a very short-term marriage. And even then, it's not to your benefit to do this. I could go through that ad nauseum, but I think I've made my point. I want to be really clear with the marital standard of living. I am horribly oversimplifying the MSOL calculation. Also, what you need to be aware of, and I have not expressly stated, is the courts now recognize that both parties are entitled to live at the marital standard of living. So, I want to make sure I'm going through every point on why quitting work or not choosing to return to work when you know you're headed for a divorce is self-destructive and ultimately futile. It is a financially costly tactic to employ to you. And sadly, it is so common it makes my brain hurt. It just goes to show that people are penny wise and pound foolish in many, many occasions, and that many people, many attorneys for that matter, don't understand the long-term consequences of short-term actions. So that's the end of this discussion. I have a couple of other examples I could give, but I don't want to make it too long, and I don't want to give away everything. So in my next post, I will discuss the strategy, the exit strategy, for a supporting spouse who wants to take pre-separation action to decrease his or her support obligation. I hope this has been helpful. Thank you.